Mr. Goodyear, because he bears the burden of proof
Mr.
in this
Whitmire, in
case, will
clause number
address you both
25,
first and
DCCR
last, with
0057,
Ms. Kirby.
you're charged with a second
Now, in
degree
opening
felony
statement, I
offense
began
of
by
possession
telling
of
you
a
that this
controlled
is a case
substance
about
from October 12th
exploitation.
of 2024.
About
And
a
how do you plead to that
47,
charge?
actually 45-year-old and
Are you pleading
47-year-old
guilty
man
freely
taking
and
advantage of a 13
voluntarily?
and 15-year-old
And are you
girl.
pleading guilty because you did
And
what they
when you
charged
think about
you?
this case,
I have here on the
actually
tablet
think
some
about
documents that have your
State's Exhibit
signature
1.
on them that the
This
state's
is a
marked as
trauma
exhibit
letter
number
wrote
1.
when she was in
Before
therapy.
you signed
got a
these, did
chance
you
to
go over
hear
them
her
with Mr.
read that letter
Williams?
to you
And do you fully understand
yesterday
it?
during her testimony.
And do you understand if
And
I
think
follow
that
the
there's
agreement
no
that you've
other
made with the
conclusion
district attorney
when
that
you
you'll be
hear
waiving or
what
giving up
happened or
any
you
right
hear
to
what she
appeal?
read to you, that
Do
she
you also
avoided
understand
this.
if you're
This
not a
was
U.S. citizen,
matter
the
of
plea of guilty or
her
no
being taken
contest
advantage
may
of by the
result in
defendant.
deportation,
Charge him
exclusion
with
from admission to the
corrupting another with
country,
drugs.
or denial of
And
naturalization
you
under
see
federal
there,
law?
we have 4 different time
State
periods.
tenders number 1.
No objection.
Within which
It's admitted. Is
these
there any evidence that
offenses
Mr.
were
Whitmire is
alleged to
not
have occurred.
competent?
No, Your Honor.
One
All right, sir, I'm going to
kind of,
find that
as
you
she
entered your
told
plea
you,
of
kind of
guilty freely
just
and
before around her
voluntarily,
birthday when
find
she
that
was
you're
turning
mentally
14 to
competent, and
15
you
in
understand
that
the
time
nature and the
period.
consequences
Do
of
you
your
remember her
plea.
testimony
Find
about
sufficient evidence
when
to find you
she,
guilty,
the
and
first
at this
count, she
time
was
find you
13.
guilty
This is
of
the one in
possession of a controlled
2021, August,
substance.
September
Sentence you
2021.
in accordance with your agreement to a term of 3 years.
She's
in
told
the
you that she
Institutional
remembered
Division
that
of the
because,
Texas
number one, it
Department
was
of
the first time
Corrections.
she'd ever smoked
You will
methamphetamine
receive
with
credit
the
on that for any
defendant. She
time
was
that you've been
13
in
years old.
custody that the law gives
She
you the
remembers
right
that
to receive.
specifically. She remembers that it
I'm going
was
to sign
hot
a
outside.
dismissal as
In
part of
her
this
memory,
plea
it was
agreement and
summertime.
clause number 25,
She remembers
DCCR
that it was the first
0056.
time
I've
she
handed
ever
you the
smoked
trial court
methamphetamine
certification
out of a
that shows
bong.
this was an
And she
agreement
talked
that
to
I
you
followed,
about
so you waived
the
your right to
attachment on the
appeal.
bong and
I also
everything about
handed
that.
you a written admonishment
She also
regarding your
told you
ineligibility
the
to
effect of
possess
that
a
on her.
firearm
She was
or
awake for
ammunition.
4 days. She had
Just thinking about
I guess
yesterday,
more of a
this is a
high,
possession
you would
case,
say,
so I'm
than
not
she'd
sure
ever
how
had
it
in her
applies.
lifetime.
But you,
So
possession,
she specifically remembers
because of the
those things.
judgment
And she
entered
also
against
told
you, you
that
could be
one of the
ineligible
reasons
to
why she
possess a
remembers this
firearm or
specific
ammunition.
time period that was sometime
Possession of a firearm
between
or
August and
ammunition could
September
be
is
the charges
because
against
she
you.
remembered that
If
the
you have any
defendant was in
questions
jail,
about
had
the
been
laws
released
that
from
make you
jail in
ineligible
early
to
August
possess
of
a firearm
2021.
or ammunition,
And that's
or
when
about
she
how
began to have
long that
contact
lasts,
with
you can
him
talk
as
to
she
Mr.
was trial.
Rojas and read
There
that
are
document
16
carefully.
photographs
All right, you can go back to
that
the
were
bailiff.
introduced as evidence in this case. You're going to have a chance to look at those
See, and
photos.
so am I going to
And
have to
each
start?
photo
And
has
this is
not
clause
just the
number
photo of-
25
but has
DCCR
the,
1019. Mr.
metadata,
Harmon's charged with
the
aggravated
location,
assault
the
with a deadly
geolocation
weapon.
information attached
And
to each
26
photo. And it tells you where
DCCR
that photo generally
0385
was
charged with
taken.
assault of a public
And
servant.
it
And
tells
what is
you
the
the
announcement?
date those photos were taken. So she told you, she saw those photographs, of course it's her.
Is
She
the
said
offer
that's in the
receipt-
defendant's
Judge, he
bedroom.
had previously
she
rejected
told
15.
you,
I re-urged that today.
that she was
This
high
is
at the
their
time of those
first
pictures. And I
appearance
think
with
when you
this
look
newer
at those, you're
charge.
not going to have any
Right.
That was
doubt
indicted
your
in
mind
March.
that she was
And my offer
inebriated
was
when she
presented to
took
run
those
concurrent.
photographs.
So 15 years
Or
in
when
each to
this
run
was taken,
concurrent.
Yes, Your Honor.
And so we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender, if that prior criminal history is correct, which means your minimum punishment would be 25 years in prison up to 99 years or life, and you understand that.
She has a specific
And you understand the
specific
offer of that
incident
15 years
that
is now
kind
for
of
both
makes that more
cases to run
memorable, which is
concurrently or at the
the
same
defendant
time.
masturbated in
You
front of her.
understand? And you want to
So
go
on that
forward on both
occasion,
of those cases
they
to
went to
trial,
his
is that
house.
correct?
Yes,
Smoke methamphetamine.
One
and
time
then
though,
he
to
began
hire an
masturbating,
attorney,
and
my
she told
people
you
are
that
going to give
it
me
was
an
taking a
attorney.
long
So
time.
here's what
She
I'm
showed
going
a
to
picture
do,
of
just
herself
because this
in
has been
broad
going on
panties,
for some
and
time.
they were
Obviously, if you
finished
get an
doing
attorney
that.
hired,
So,
they can step in at any
certainly,
time. They
she's
need to do
15
that
years
as quickly
old
as possible
with this
because I'm going to move your
47-year-old
cases
cousin
to the trial
masturbating in front
docket.
of her
Mr.
as a
LeBlanc will
memorable
begin
experience for
preparation
her.
for trial.
The design that the
And
defendant
if
drew on her upper
if
thigh
they
when
get
she
someone
was
hired,
13.
they'll substitute
There's a
in.
photograph
Otherwise,
from her
he will go
phone,
ahead and be prepared
that was
when that
downloaded
trial
that
day
shows
comes
that
up, okay?
design.
Okay.
All right.
In
you can begin.
addition, when you look at the photographs that were taken in his bedroom in May of 23, you can see the design on her leg.
Yes, Judge.
So again,
We'd be
she's
seeking
not just
to
making up.
So,
documents.
Mr. Harmon,
There's
also, and I
evidence
know
to
you've
establish
gone
to
over that with
support
him
the
as well,
testimony she
Mr.
gave
LeBlanc, that if you're found
And
guilty in both of the
time that
cases,
these
because
things
those are
happened,
different
she
offense
testified
dates,
that
that the
he would have
cases
known
could be
what her age
stacked
was.
or run
But all we have to
consecutively.
prove
If
is
you're
that he
given a
was reckless
sentence in
in that
one and then
fact.
they
In
go go to
words,
trial
that
in the next,
he
then the
essentially
district
should have
attorney's
known
office
what
can
her
ask
age
me,
was.
and then it's up
And in
to
those
me if those
circumstances, ladies
cases
and
are
gentlemen, I
stacked
would-
or
I would
run at the
submit to
same
you that
time.
we
Do you
proved beyond
understand?
reasonable doubt that he was aware
Not
that she was
concur.
a minor,
It's,
that she was under
well, it would be up to
age
me.
based on his
So
experience
it
with her
depends
and his
on,
knowledge
if we
of
go to
her.
trial on both of those cases,
also
I would hear all
charged
the
with
evidence
public
in both of the
indecency.
cases, and if I decide that whatever
The defendant,
sentences
Eric
you're
Isaacs,
given in
who's
each
been
of those
identified by
cases,
the victim
if
as
I think
one
they need
that
to be
was involved
stacked,
in
then
this.
that's up to me. It's not a jury
Knowingly,
question, it's a
we've already
court
talked
question.
about what knowingly means,
Okay.
but in this
The
case,
plea
the idea would
agreement,
be
if
that
you
he
wanted to
is
enter a plea,
aware of the
is
probability
negotiated that they would run at the
he
same
was
time,
masturbating
if
and
you
that she
wanted
was
to take the
present.
plea deal.
Oh,
But if it goes
and
to
that she was a
trial,
minor.
then it becomes up to me if you're
For
found
purpose
guilty in
of
both.
personal
Does that make
sexual
sense?
arousal
Okay.
or
And you want to go to
gratification,
trial.
Yes.
Or
All right, we'll get it set for trial then. You can go back
to
with the
lure the minor
bailiff.
into sexual activity.
Now, the second part.
Good morning. Are you Joseph Roberts?
I don't think there's any evidence he was trying to
This is
lure her into sexual activity, but I don't think there's any
20-34226.
question
Mr. Roberts.
that what he was doing was for his own sexual gratification. That
Looks
the
like
state
you were
has
on
proven beyond a
probation
reasonable
for
doubt
the
each and
felony
every element
offense of
these
driving while
offenses, and we actually
intoxicated,
find
and
the
that you were
defendant
placed on probation November 30th
Good
of
morning, ladies and
2020.
gentlemen. Thank you for being
That was a
back here
7-year
today.
term in prison that was
I
probated
also
for
watched
7
as
years.
You listened
Some of the
yesterday.
allegations, it
I
looks
can
like
tell that
there
you
is
guys
an
are a smart
additional
group of
driving while
people, and you're really
intoxicated
taking on
charge
this
from
case.
April
And on
26th
behalf
of
of Mr. Isaacs, we really
2026.
appreciate your time.
Curfew
If you were
issue.
anything like me, you left
Operating a vehicle
yesterday
without an ignition
confused.
interlock device, and then
so many question marks.
some minor fees. Mr. Nix has
Was she
filed
telling the
a
truth? Does she
motion
remember
asking
the
that I
truth?
set bond in your cases. Currently,
Could
there is
somebody
no
who has
bond.
smoked that much meth
He's
remember
also handed
correctly?
me, it looks like there was a
Did something happen? What happened?
30-day treatment.
Mr. Goodyear told you
at
that
Level Up
it
Treatment
is
Texas.
legally sufficient to have a period of time and
that
not
you went
necessarily
to
pinpoint, but why?
April 26th
Would
through May
that have helped us
29th
all
of this year.
if we knew a
Mr.
date or a time?
Robert, especially you
Something
and raise
that
your right hand, please, sir.
pinpointed
Do you
us
swear or
to
affirm the
all
testimony
of
you're going to
these
give in this hearing will be the
alleged
truth, the whole
offenses?
truth, and nothing but the truth?
How does my
right,
client
thank you. Mr.
defend
Nix?
against
Your Honor,
a
we'd ask that the
6-month
court set a
period of
reasonable
time?
bond. My client's willing
Ladies and gentlemen, I
to
don't have a
forfeit his
chance
right
to
to
show you an
drive,
alibi
would wear a
because we
screen
don't know
device,
a
comply
date.
with any curfew set by the
If
court.
there was a
As the
specific
court can
date
see,
or specific time,
he did not
perhaps
have
Mr.
any
Isaacs
issues on
could
the
have gone through
probation
his
for
phone.
several years
Maybe he was
until
out of
he
state
picked up
that
this
day.
new
Or
offense.
maybe he was out late. We don't
It was
know
not
because
his
we don't have
vehicle. There
that
were
date
several
to
other
defend
occupants in the vehicle.
She said she had lots of pictures on her
Which would
phone.
explain why he
Just
wasn't
like any other
complying with the
teenager.
interlock device.
I have lots of
He
pictures on my
obviously
phone too,
knows
and
that
I
he made a
can pretty
pretty
well
terrible
tell you what
mistake.
I've been
And
doing
if the
every
court
day
will
over the
acknowledge,
past 10
just 3 days after
because
his
of photos
arrest,
or
he
text
voluntarily
messages,
did a
things like
month
that.
of inpatient rehabilitation.
Don't check your
Also,
common sense at the door.
I'd like
Let's
the court
think
to
about
take knowledge
that.
of, and although
Why
I didn't put it
can't
in my
we
motion,
prove
I
this
think
based
we've
on
made
something on her
the court
phone?
aware
Why
with the
can't the
district attorney.
prosecution point you
His
to a
daughter
certain
was
day and
brutally
say, look,
murdered
there were all these calls
about
between
10
them on
days
just
ago
this
now.
day, and
Somewhere
this
around
makes
there.
sense that he was
About
on his
2
way to
weeks
pick her
ago.
up, or she
Her
called and
daughter's,
said, hey, are you on your
his
way? And he
daughter's
called back and said,
funeral
yes,
is
I'm
this
on my way.
Saturday.
Obviously, we
She
don't
was
know
the
what was
victim
said,
of one
but
of our
wouldn't that
homicides
have
here in
helped?
Beaumont out of a domestic
There
violence
was just
situation with what
something
appears to be
to
a
point us in that
boyfriend or
direction.
ex-boyfriend. He'd like to, be
The state's
obviously
job
on
is
bail
to
so that he
paint
can
this
attend
picture
his
for
daughter's
you, to make
funeral.
this clear for you.
He would adhere to
If
any
you're anything like me,
any
I left
recommendations,
yesterday
anything that the court requires of him of his
Question
bond.
marks.
He's also just
Did this
been
happen? How did
accepted
it happen?
into an
Is she
IOP
making this up?
program
Is she credible?
where he will be
Testify
doing
yesterday that she
counseling,
had smoked meth with
therapy for alcohol,
her brother.
substance abuse.
You had also
As part of that
heard her
program,
testify
they do
that her
random
brother and her
alcohol
grandparents
and
may
drug
not like it if
tests.
she went over to his house, to Mr.
This is
Isaac's
something
house,
that his
because
insurance offered him
there was some
after
family
finding
drama
out
going
about
on.
his
She
daughter.
alluded to something
So
going on.
not
We
exactly
really didn't dig
related to the
into it,
DWI, but it's
you can
related
tell
to
that
finding out that his
something's there.
daughter was
Some sort of
murdered and the
drama
way
is
she
there.
was murdered. He's taking
Is it
advantage
possible
of
that
that.
she has
Obviously,
something
he
against
doesn't want
Mr.
to have
Isaacs, or
an
maybe her
episode
brother
where he
has
falls
something
off
against
given
Mr.
what his
Isaacs?
family's going through.
I don't know.
He
I'm not
is
suggesting
not the
that.
sole provider of his family,
Is it
but he is the
possible?
main provider
You
of
heard
his
her
family.
testify that when
They have 2 homes,
she
one home
allegedly
that they
smoked
live
with
in,
Mr.
another
Isaacs, it
home
was
that
the
they haven't been able to
this
sell,
different
so they
high,
have 2
something she'd
mortgages
never
to
felt
pay
before.
for and bills. Is that correct,
Is it
Nicholas?
possible that
And right now, I'd ask
maybe there was
if Mr.
marijuana
Roberts
oil in there? I know I
can
keep
give
harping on
more
that.
details to the
I just
IOP
don't
than
know.
I might be able to.
Does that make
Can you
sense that
explain
it
to
could
the
have been in a
judge?
bone?
What's
Does that
the
make
name
sense
of
that
it,
it
or
could
where
have
is it?
made
What's
her
it
feel
through?
weird?
Trust Health.
Made her feel different?
Trust.
Trust.
I don't know.
Trost.
Trust.
Ladies
Yes,
and
ma'am.
gentlemen,
We
I
do,
know I'm pressing on this
3-hour
idea of
sessions,
was it meth
3
so
days a
much,
week.
but it is so important.
Is it
in
on
this
the
case.
Group.
Is it
I
online
do
or
the
in
virtual.
person?
I do
You did not
virtual.
hear from a
Yes, ma'am.
scientist. You did not hear from a toxicologist. You didn't hear
They
from
do
a
the random
medical
drug screening
provider of any kind.
once a week,
You
and
did
we
hear
get a
from the
therapy
detective,
session with a
but she
counselor
said that there was nothing
also
to test.
throughout the week.
So we are relying on the
How do you do your
testimony of
random
a
drug screen?
child
They send an Uber
to
and
prove that a
bring it
substance was
to
methamphetamine.
She's
She's just a kid.
West on 9th
I don't
Avenue.
know, but the
Have
prosecution
you already
has
done
to
one of
prove
those?
meth.
I have one set up
Methamphetamines.
tomorrow.
That's the drug that they have to prove
Where do you
for
work?
this charge.
With
Stay.
Bechtel,
There were a lot
environmental safety
a
and
lot
representative.
of I don't know, I don't remember, I can't
Okay.
recall, maybe, possibly
So if you're,
in her testimony.
how would you get to and from work?
I wish
and
I had a
things like that
transcript
if
of
you're
how
going
many
to
times
drive?
she
Yeah,
said
my
that, just
nephew
because
also
she
works
didn't
out there,
know.
same shift. So I can
Ladies and gentlemen,
ride with
she
him.
knew she was coming here for a jury trial yesterday. This date has been on
Just for the
everyone's
record, I
calendar for a
am
long time.
reviewing the
And I
court's
urge you
file.
to remember
and
that. Use
part
your
of that
common
does
sense.
include the
Proof beyond a
probable cause
reasonable doubt,
affidavit
ladies
for
and
the
gentlemen, is the
new
standard here. And
driver
the state
intoxicated. I
has
was
not
looking to
met its
see,
burden of
but I don't
proving
know
this
that
case beyond a
It's
reasonable
not yet
doubt.
been received, Your
On
Honor.
behalf
Testing has
of
not
Mr.
yet been
Isaacs,
completed.
I ask that you
I was trying
return
to
the
also
only
see, do you have a
verdict
copy of that
that
previous
is
pre-sentence
consistent with the
report?
I had it on
evidence,
my computer
the
earlier. I had to
law,
pull it back
and your
up.
oath.
Ours
which is
didn't,
not guilty.
because it's an
Thank you.
older case, it's not in here.
You're not going to hear the judge instruct you that I'm
Okay.
required to prove
Please, ma'am.
a specific date beyond reasonable doubt, because it's not true. People are convicted in the state of Ohio every day of the week when they're charged with date ranges. Certainly, there are going to be things that she does not remember, and Ms. Kirby asked her a number of different questions. But when it came to the really important specific issues you're going to decide, she was very specific and she was very certain. For example, how many times did you hear? the
I guess
defense
an
attorney
issue that I
ask
have
her,
that we're going
"Are
to have
you
to
sure
talk
it was
about. So
that?"
Mr. Roberts signed a no
Over
driving
and over
agreement
and
with
over.
probation
And this
March
18-year-old
19th.
kid sat there
And
with this
then
adult
the
who's
allegations
over
are that
and over and over again. Are you sure? Yes, I'm
a
certain.
month and a
How are you
week
sure?
after
Because
is
I've used it
this
for a
when
long
this
time. Are you
happened,
sure?
he
Couldn't
was
have been this.
driving.
No, I've
So
never
he'd
smoked
already
marijuana oil. Are
told
you sure?
someone and
Yes,
signed an
she
actual
described
document
why
saying
she's
he
sure.
wasn't going to
All the
drive. So
characteristics
obviously
of
the argument of I'm not going to drive
methamphetamine.
gives me
It's
some
exactly
concern
the same
because you've
thing that he
already
gave to her.
been there,
I've
done
talked about
that.
their ages. When you look at that call log, you can count if you like to. I have 2023, May 21st, 2023 till December 29, 2023.
How many set of keys do
There
you
are
have?
138 Facebook calls.
No, to your
No,
car.
oh, just,
and a
that's,
15-year-old girl.
I've had one.
Why is that?
For the same car?
105.
We'd be
of
willing
those
to turn
calls
over both sets of
were
keys.
initiated.
Wasn't driving his car on this date.
Fair
She told
enough,
you about
Judge.
how he
So
would
I'm not
try
saying I'm
to
not going to
come
set
over,
it a
try to
bond,
come
but these
over.
are the
Why
concerns
is
that
a
obviously
47-year-old man
um,
on Facebook calling a 15-year-old girl?
there was something going on
105
that I'm not
times.
quite sure about,
And
but
why would you
obviously
need
there
to
was
talk
something
to your
going on
15-year-old third
for there to be a
cousin
no motor
138
vehicle
times in a 6-month period of time?
drive form
Yes, ma'am.
signed a
Same
month
thing with the
before. So
timeline
there
for
were some
2023.
concerns already.
I have
164 contacts.
previous
That includes
PSI.
messages,
Sounds like
phone
it's
calls,
coming
everything.
as well over here. Thank you, Mr. Nichols.
164 contacts between a 15-year-old girl and her 47-year-old third cousin. 125 of those contacts, 125 were initiated by him. Now, why is that? It's because what she's telling you is what happened. In a normal relationship, a normal cousin relationship, which the defense would have want you to believe was the
Mr.
situation.
Nichols, what's your position?
Judge,
You
I've
don't have
reviewed
that kind of interaction.
Ms. Botfino's email
It
correspondence
was
with the
falling
court
out
and
between
Mr.
Eric
Nix
and
talking
her
about her position on
She
this
said
case.
maybe
We are not
something was
opposed to a
Well, guess
reasonable bond
what?
being set.
Miss Kirby had the
Obviously, we
ability
have
to
concerns,
question.
same as
She
the
could have
court
asked,
with
what
the
was
driving.
problem? Did you not like the driving? What came of that?
I believe
Why
the
is
scram
that?
will take care of the
Did
any
she ask any
concerns
of those
about
questions?
substance abuse,
No.
but
She wasted closing argument.
there's
to
just not an
believe,
easy
well,
way
maybe
to
there was a problem with
be
no
completely
information
certain about the
whatsoever to
driving.
support it. What's her motive to lie?
given the circumstances,
This
given
case
his
began
willingness to do what
with
he's
a
already
trial.
done and what he's going
She had
through,
no
that's why the
expectation
state
the
does
police were
agree
ever
for a
even going to get
reasonable bond in
involved.
this case, Your Honor.
And again, talking about credibility of a witness, she told you
Okay.
that part of the reason she's
so
conflicted about the idea of reporting at all is because
Mr. Roberts,
she bears the responsibility of her own choices.
I want to
And
make
she's
sure you
18 years
understand.
old.
I'm going to set
And
a
she's
bond,
telling
and
you
if you
that
make
the
that
reason why
bond,
she
there'll be
was
some very
reluctant is
specific
because, hey, I
conditions.
made
Some
the
of those
decision.
conditions are
I'm the
conditions
one
you
that
already have
decided to
on
go
the
over there and do
probation.
this.
At
What did
this
she do
point,
when she
understand that you're
testified? I
going
asked her,
through
"Did
something
he ever
very
touch you
traumatic in
sexually?"
your life,
No.
which tends to
Did he do
lead
this? No.
for people who
She had
have
every
substance
opportunity
abuse or
to say
alcohol
whatever
issues for
she
those to get
wanted.
worse.
And when she had a chance to
If
make it
you
worse
don't
for
take
him,
advantage
she did
of
it.
this opportunity
And by the way, if
while
you
you're out
say,
on bond, I can assure
I
you
don't
you're
remember,
not going
I
to
don't
get any
know to
opportunity.
things,
You're going to be back in jail, and
that's
you're going to be looking at
called
going to prison
being
for the 7 years
truthful.
that you've already agreed
He
to
is
on
on
that
a
underlying
FaceTime
case, and
call
who
at this
knows what
point.
on the
He
other.
is
So this
47
is make it or
years
break it going to prison type thing,
47
even though
years
it's
old,
just a
talking to
bond. Do you understand?
16-year-old girl. And in that FaceTime, what is he doing?
So what I'm going to do
He's smoking
is
methamphetamine
grant the
from the
motion
ball.
to set a bond in cause number
Now, she
20-34226.
screenshot that, sent him with that
I'm going to set the
cartoon
bond at
character, basically make fun of him, like, you're
$25,000.
an idiot.
I am going to
But
order as a condition
why?
of that bond
Why
that
did he
you
feel
wear a
comfortable
scram device at
to
all
smoke
times. If there is
methamphetamine
a
in that
positive
phone call
alcohol
with her?
screening, I will know
The
about it.
answer
There will be a
is
warrant.
because
There
he
will be
had
no
done
bond,
it
and we'll be looking at
before.
that 7 years.
He
It's
had
that
done
simple.
it before, just as she said.
Also, as a condition
and
of that
gentlemen,
bond, you are
when you
not to
consider
drive any
all this
vehicle
evidence,
ever.
When you say all
period,
the
under any
exhibits in the
circumstance. If
testimony,
you're with people
I
and
would
they're
submit to
drinking,
you
then you're not the
that
one that
state's proven
drives.
this case beyond a
Y'all
reasonable
walk,
doubt
y'all get
and
an
ask you
Uber,
find
you
the
do
defendant
something
guilty as
else.
charged.
You understand?
Thank you.
Without disclosing
Also,
the
I am
nature
going
of
to
the-
order as
the
a condition
verdict
of
as
your
the jury
bond
reached
that
the
you,
verdict.
and really I want it to be a condition of
If you could
probation
give
as
the,
well, to
verdict
modify your
forms to
conditions
Ms.
of the
Carrillo.
probation you're currently on.
Verdict form
To
reads
order
as follows.
that you
Count
can,
one.
continue
We, the jury, find the
that
defendant,
program,
Eric
the
Isaacs,
IOP through
guilty of
trust help.
corrupting another with
I
drugs.
want
We
proof
further
of
find the
that,
substance was
verification of that,
methamphetamine, a
since your
Schedule II
probation officer,
substance.
each
There
week
appear
or
to be
whatever you
12
can do. If it's
signatures
online, you should be
attached.
able to print something
Verdict
out,
form.
to send to them
Count
to
two.
show that you're
We, the
you're
jury,
doing the
find the
3 hour
defendant, Eric Isaacs, guilty of corrupting another
meetings,
with
as
drugs,
well
and
as
find the
any
substance
drug or
was
alcohol screen that you
methamphetamine.
get done. You need to get
Count
those results
three
also
is
to your
also
probation
a
officer.
guilty finding.
Yes, ma'am.
So that'll be a
Four
condition of
is
bond
a
as well
guilty
as your
finding,
probation.
12 signatures, again attached.
Any other
Count five
conditions that I
is a
didn't
guilty
take down?
finding,
Those are the ones
signatures
that I
attached.
said better.
Count
Take that
six
over.
is a guilty
Okay.
finding also
All right,
with,
so
finding
what
the
we'll
substance
do,
was
if you make that
methamphetamine,
bond, you'll have
Schedule
another
II
court date,
substance.
stay in touch with Mr. Nick, he'll let
Thank
you know when you
We're
need
on
to
the
be back
record
here
outside
in
the presence
court.
of the jury.
And again,
Should
whatever
we hear
you need
anything
to
from the
take care
state?
of to keep yourself doing the
I
right
know
thing,
Mr.
going through what you're going through,
Isaac
you need to make
Custody
sure and
Labs
get
who
that
asked you
done.
to revoke his bond
Because
and
being in
hold
prison
him
won't
pending
help the rest of
sentencing,
your
and we would
family.
ask for a separate
Okay.
sentencing date so
All
that
right.
they can be
Thank
present.
Yeah,
you,
that,
Judge.
yes, sir.
Address the
Okay.
court.
We did have a
I'll
bond
shoot a
right now,
message
so.
over.
Okay,
Thank you, I
then
appreciate it.
we'll call